Hello, and welcome to the webinar on Understanding and Preventing Harassment in the Workplace, Roles and Responsibilities of Organizations. My name is Anne Clennett, and I am a Policy and Program Consultant with the Alberta Human Rights Commission. I am located in the Calgary office, and I will be your moderator for this webinar. Today's presenter is Sushila Samy, Diversity Specialist with the Alberta Human Rights Commission, and she is joining me from her office in Edmonton. Welcome, Sushila.
Hi, Anne.
The information on understanding and preventing harassment in the workplace can be used by any organization. The human rights legislation referred to in this webinar is the Alberta Human Rights Act. The commission referenced is the Alberta Human Rights Commission. If you are attending this webinar from outside of Alberta, or if you are in Alberta but are from an organization that falls under federal, territorial, or provincial jurisdiction, check with your federal, provincial, or territorial Human Rights Commission for more information. We would like to advise you that the information presented in today's webinar is not legal advice. It is information that your organization can use to prevent harassment in your workplace. Please note that this webinar is being recorded, and you will be able to visit this recorded session on the Alberta Human Rights Commission's e-learning webpage. The webcast will be available approximately 1 week following the live webinar date. As well, the materials shared will be available as downloadable resources. This webinar is scheduled for approximately 1 hour. The first portion of the webinar will be a presentation, and then we will have time near the end for questions and answers. Before starting our presentation, we would like to invite you to take a poll. We will be using polls throughout the presentation, which allows us to get a feel for our audience and helps us to adapt our content to meet your needs. It gives you time to reflect on your organization's operations, assess your understanding of the concepts being presented, and think about opportunities for moving forward on your own harassment prevention initiatives. Please note that all of your individual answers are anonymous and confidential, and only the total responses appear on the screen as numbers or percentages. So let's try our first poll question. Tell us how many of you are in the room participating in this webinar, and please ensure that you include yourself in this number. So go ahead and enter the number and click Submit. Thank you for providing that information. It helps us get a better sense of how many people and organizations are interested in this topic and are looking to better understand harassment and how to prevent it in their workplaces. Let's move on to the second question. What type of organization are you representing? Are you from a small business with 1 to 49 employees, a medium-sized business with 50 to 99 employees, or a large-sized business with over 100 employees? Are you from a nonprofit agency, an educational institution, the government, or a union? Or are you from another type of organization? Go ahead and choose your response if you haven't already done so. Okay, the answers are starting to come in. And it looks like we have quite a few of you from large-sized businesses, but we do have a good cross-representation from a wide variety of workplaces. And that reinforces that all types of organizations want to create a respectful workplace and that you are looking for ways in which to make your workplace diverse, respectful, and inclusive. So moving on to our next poll question, tell us why you are attending this webinar. Have there been incidents of harassment in your workplace? Are you looking for information on how to respond to allegations of harassment? Would you like to learn about how to prevent harassment in your workplace? Or do you just have a general interest in this topic? Or all of the above? And for this question, you can choose more than one answer, so please go ahead and make your selections. Okay, the results of our next question are coming in. And it looks like a number of you are indicating that you would like to learn about how to prevent harassment in your workplace, but that all of the other answers are reasons for attending. And of course, those are common issues in workplaces, and the information provided today will help you address these needs. So thank you for participating in the polls. Now I will turn it over to Sushila to begin the presentation.
Thank you, Anne. Welcome to all of you who have joined us on this webinar. In today's presentation, we will discuss harassment that is based on the areas and grounds in the Alberta Human Rights Act. That is, what is harassment and under which areas and grounds does the Act protect against harassment. We will also discuss employer responsibilities in preventing harassment in the workplace, and we will discuss the role of managers in dealing with harassment complaints. At a workshop, a manager once said he has a very diverse staff, and in the mornings the staff would be sitting at the front desk chatting, and he would often hear them making sexual and racial jokes. He said since no one complained to him, he thought everything was okay. Then one day, one of the employees walked into his office and asked him why he was not doing anything about the jokes that were going on in the office. The employee told him that she works in the front office, and since they all stood around her office, she had no choice but to listen to the offensive jokes and banter on a daily basis. When I asked her why she did not say anything earlier, she told him that she felt uncomfortable complaining about it, as he heard it every day and did not do anything to stop the offensive jokes, and she thought that he approved of it. She told him that she had enough of it, and she wanted him to put a stop to it. The manager said he was shocked that their workplace was not as respectful as he thought it to be, and wanted to know what he should do. I believe that it's easier to prevent harassment than to deal with it after a complaint is made. And this is the reason I emphasize training for all employees on how to create and maintain a respectful and inclusive work environment. The Alberta Human Rights Act prohibits discrimination on 15 grounds. You can find information on the areas and grounds in the Commission's information sheet entitled Protected Areas and Grounds under the Alberta Human Rights Act, and is available on the website. A link to this information sheet is located in our resource list. The prohibited grounds of discrimination in the Alberta Human Rights Act are race, religious beliefs, color, gender, gender identity, gender expression, physical disability, mental disability, age, ancestry, place of origin, family status, marital status, source of income, and sexual orientation. The Alberta Human Rights Act protects individuals from discrimination in the following areas: statements, publications, notices, signs, symbols, emblems, and other representation, goods, services, accommodation, and facilities customarily available to the public, tenancy, employment practices, employment applications and advertisements, and membership in trade unions, employers' organizations, or occupational associations. For a detailed explanation of the protected areas and grounds, you can also view the webcast, the Alberta Human Rights Act Overview, on the Commission's e-learning page. A link is available in the resource list. The Act prohibits retaliation. An employer cannot take any negative action against an employee for making a complaint, trying to make a complaint, giving information about a complaint, or helping someone else make a complaint. For example, if an employee provides information as a witness in the investigation of a complaint, the employee cannot take any negative action against that employee for assisting in the investigation. The Act also prohibits individuals from making complaints with malicious intent that are frivolous, that is, with no merit whatsoever, or vexatious, made with the sole purpose of harassing another person. Harassment is a form of discrimination that is prohibited under the Alberta Human Rights Act. It may be based on one or more of the grounds in the Act and can be based on gender, gender identity, gender expression, which is sexual harassment, racial due to one's race, color, or ancestry, because of one's mental or physical disabilities. It can be based on religious beliefs or due to place of origin, family status, marital status, age, sexual orientation, or source of income. Harassment occurs when someone is subjected to unwelcome and uninvited verbal, non-verbal, or physical conduct. Harassment tends to have a negative impact on the employee's work performance and creates an intimidating or hostile work environment, not only for the individual being harassed, but also for others in the workplace. Harassment can be one serious incident or a series of incidents. One incident, such as physical assault, may be enough because of the seriousness of the conduct to constitute harassment or to create a poisoned work environment. When jokes or rude comments are made, a pattern of conduct may be necessary before harassment or a poisoned work environment will be found to have occurred. The following are some examples of harassment: derogatory remarks because of one's gender identity or gender expression, jokes, innuendos, or taunts about ancestry, place of origin, or disabilities, display of racially offensive images, intimidation, and sexually offensive gestures. We are focusing on sexual harassment in this section because sexual harassment, once a hidden and ignored problem, has received much publicity in recent years. The majority of requests for workshops in the Commission's workshop program are to inform and educate employees on their roles and responsibilities in preventing sexual harassment in their workplaces. In his book, Sexual Harassment, A Guide for Understanding and Preventing, Arjun Atwal states that studies confirm that sexual harassment is one of the most serious and widespread problems facing women in employment today, and that people are surprised to learn how deep-rooted the practice is. Sexual harassment is a form of discrimination based on the grounds of gender, gender identity, and gender expression in the Alberta Human Rights Act. It is any unwelcome sexual behavior that adversely affects or threatens to affect directly or indirectly a person's job security, working conditions, prospects for promotion, earnings, or getting a job. It includes unwelcome sexual advances and unwanted requests for sexual favors. It can be verbal, non-verbal, or physical behavior of a sexual nature which affects a person's employment and working conditions. It can also be one serious incident like sexual assault or a series of incidents. One form of sexual harassment, called quid pro quo, is when someone in a position of authority attempts to exert it over another employee with negative consequences. For example, a supervisor using their authority to decide on a person's job security, working conditions, promotions, and earnings attempts to coerce someone that works for them to grant sexual favors. If the worker agrees to the supervisor's request, tangible benefits follow. If the worker refuses, job benefits could be denied. Another form of sexual harassment is perpetrated by a co-worker or a client who makes unwelcome sexual comments, sexual jokes, and unwanted physical conduct. All sexual harassment demeans and humiliates the employee and creates a poisoned work environment. It is emotionally abusive and creates an unhealthy, unproductive workplace. Behavior that is acceptable to both parties, such as dating or flirting, would not be considered sexual harassment. Examples of sexual harassment include verbal, which is suggestive sexual jokes and remarks about a person's body, clothes, appearance, or sex life. Unwelcome invitation or requests for dates, whether direct or indirect. For example, not taking no for an answer from an employee who does not want to go out for lunch or to date another employee. And outright demands for sexual favors. Non-verbal, including display of pornography or other sexually offensive or derogatory images. Leering, ogling, or lewd gestures. Physical includes unnecessary physical contact such as touching, patting, pinching, physical or sexual assault, which is a violent attack. Physical or sexual assault is a criminal offense, and the victim of the assault would have to report it to law enforcement authorities. Although the majority of sexual harassment complaints are made by women about men harassing them, anyone can experience sexual harassment, males, females, or transgender individuals. Anne will now facilitate another poll for us.
Sushila provided some examples of harassment. Think back to the examples that she shared with us. They included displaying pornography or other sexually offensive images, derogatory remarks based on gender identity or gender expression, suggestive sexual jokes and remarks about one's body, clothes, or appearance, and unnecessary physical conduct such as touching, patting, or pinching. Did any of those examples surprise you? Go ahead and answer the poll, selecting those that you may not have considered to be examples of harassment. For this question, you are able to choose more than one answer if there were a few that surprised you. So go ahead and make your selections if you haven't done so already and click Submit. Okay, your answers are starting to come in. Let's have a look at what you thought. It seems that quite a number of you were surprised that the displaying pornography or other sexually offensive images could constitute harassment, and that unnecessary physical conduct such as touching, patting, or pinching could constitute harassment. As Sushila mentioned earlier in the presentation, all of those listed there are examples that could be considered harassment. She will now share some details about harassment that is not on a protected ground.
Harassment not based on one or more of the 15 grounds in the Alberta Human Rights Act cannot be dealt with by the Alberta Human Rights Commission. For example, micromanaging work or belittling a worker because of one's personal dislike and not because of their race or gender or any other protected ground in the Act is harassment and can be harmful to the individual experiencing it and to the organization. However, it is not discriminatory under the Alberta Human Rights Act. This form of harassment, which is not on the prohibited grounds in the Alberta Human Rights Act, has to be dealt with by the organization's harassment prevention policy, a collective agreement in unionized work environments, or by the courts. There are many consequences when employers do not prevent harassment in their workplace, and I'll give you the 10 most common consequences. When there is harassment, employees may quit working for the organization without informing anyone of the reason. As a result, the employer will not know what is going on in the organization and will see a high turnover of staff. Absenteeism will likely increase. Employees will begin taking sick leave or other leave and not coming to work regularly as they are fearful of being harassed. Employees are likely to be less productive than they would otherwise be because they are either dealing with the harassment or trying to support those that are being harassed. Employees may not be loyal to the organization. Employees are less likely to be loyal to an organization that does not respect them and that allows harassment in its workplace. Harassment creates a poisoned or hostile work environment for the employee being harassed and others in the workplace. A poisoned work environment is the opposite of a respectful work environment and includes unwelcome, insulting, and degrading comments and offensive behavior. When the organization does not deal with harassment and allows it to continue, employees may bring their complaints to the Human Rights Commission, or they may take other legal action through the courts or through their unions. When complaints are made at the Human Rights Commissions or when other legal options are taken, it could become costly for the organizations to deal with. For example, most organizations involve their legal counsel to help deal with a complaint made to a Human Rights Commission. Further, if there's found to be harassment, the organization may be responsible for settlement costs, such as damages for injury to dignity and self-respect and lost wages. In a recent harassment complaint in British Columbia, the BC Human Rights Tribunal ordered the employer in the complaint to pay $15,000 just for injury to dignity, feelings, and self-respect. The cost to hire and train new employees to replace those who have left because of the harassment would be an additional cost to the organization. Once a complaint goes to a human rights tribunal or to the court, the decision on the complaint becomes public knowledge and is reported in law journals and may receive media coverage. This could result in a negative public image for the organization. Even if the complaint did not go to a human rights tribunal or court, the employee who was harassed would most likely tell their family and friends, which would still create a negative image for the business. Harassment, when dealt with, may lead to violence in the workplace. In one example I'm familiar with, co-workers began teasing another worker because of his accent and disability. When managers did not do anything to stop the behavior, the worker got into an argument with one of his co-workers who was teasing him, and it escalated into a fight. Anne will facilitate another poll for us.
Before Sushila discusses employer responsibilities as they relate to harassment in the workplace, we want to ask you, which of the following do you feel are the responsibilities of the employer? Do you feel that employers have an obligation to provide a safe and healthy work environment? That an employer is responsible for harassment that occurs outside of regular work hours if the employee was asked by the manager to work after hours? That the employer is liable for harassing behaviors in the workplace, or all of the above? Again, you can select more than one answer for this question. All right, go ahead and make your selections if you haven't already done so, and click on the Submit button. Okay, the answers are starting to come in. Let's see what you thought. It looks like the overwhelming majority of you are indicating that all of the above, that they are all responsibilities of the employer. And of course, the answer to this question is number 4, all of the above. They are all responsibilities of the employer. I'm now going to turn it over to Sushila to provide more detail about the responsibilities of employers.
Here are the 4 main responsibilities of an employer in preventing harassment in the workplace. Employers are responsible for maintaining a safe, healthy workplace free from harassment for all employees, customers, and clients. An employer is usually liable for any harassment that occurs in the workplace, and especially if management knew or should have known about the harassment. This includes situations where they observe harassment or when an employee informs them or when a complaint is made to them. The employer is legally responsible for harassment in the course of employment, whether it takes place within or after office hours or outside the usual workplace, as long as it is work-related. For example, when an employee is asked to attend a company-sponsored event, any harassment they face at the event would be considered harassment in the course of employment. The employer is responsible for the harassment of its employees by supervisors, co-workers, and in some circumstances, clients of the employer or other third parties to the employment relationship. Human rights tribunals have frequently stated that an employer should be held responsible for the harassment caused by supervisory personnel.
Okay, we're now going to take some time to reflect upon our own organizations. So I'd like you to take a minute to think about what actions has your own organization taken to prevent harassment in your workplace. So for this question, there isn't an official poll question where there's space to type your answer on the screen. However, feel free to jot down your answers at your own desk or just think about what your organization has done to prevent harassment in your workplace. Okay, just take a few more seconds to think about that question. All right, you can wrap up your answers, and it's important to know what your own organization is doing to prevent harassment in your workplace. If you aren't sure about what your organization has done, this is a great opportunity to take some time to familiarize yourself with what your organization is currently doing.
Employers can lay the foundation for a respectful and workplace and prevent harassment in their organizations by developing and implementing an effective harassment prevention policy that shows their commitment to a harassment-free workplace. Make sure that all employees have a copy of the policy or have access to the policy. The policy could be provided online and or posted in areas where employees congregate, example, the lunchroom. Ensuring that employees understand the harassment prevention policy. Make sure that you explain the purpose of the policy, how to make a complaint under the policy, who they should complain to, how the complaint will be handled, what steps will be taken if the allegations of harassment were substantiated, and any other relevant information regarding the harassment. If you would like to develop and implement a harassment prevention policy, you can listen to the webcast, Developing and Implementing an Effective Harassment Prevention Policy, which you can access on the e-learning page of the Commission's website. There is also a link to this webcast in our resource list. Providing respectful workplace training. Provide an understanding of what constitutes harassment and what employees can do to assist the organization in creating a respectful, inclusive workplace. Role modeling the behavior that is expected of employees. Remember that actions speak louder than words. Employees will follow the lead of management.
Now that Sushila has provided information on preventing harassment, let's take a few more minutes to think about and answer what additional steps could your organization take to prevent harassment in your workplace. Again, this isn't an official poll question, but feel free to jot down your answers or just think about other steps that your organization could take to prevent harassment in your workplace. take a few more moments to finalize your answers. As you finish up with this question, I will turn it back to Sushila to talk about management's role in responding to a complaint.
As I said at the beginning of the presentation, my experience shows that managers usually say that their organizations are respectful and inclusive until someone complains of being harassed. It is only then that they begin to wonder if their workplace is as respectful and inclusive as they think it is, and how they should deal with a harassment complaint. That's why it's important to provide training to managers and supervisors on how to prevent harassment and to respond appropriately when complaints of harassment are made. It is also a good idea to regularly review the process you have put in place to respond to complaints. This helps ensure that you have an up-to-date process that can be implemented easily. This is particularly important when there have been staff changes within your organization or when there are changes to the human rights legislation. For example, in December 2015, gender identity and gender expression were included as prohibited grounds in the Alberta Human Rights Act. If you did not amend your policy to include gender identity and gender expression, managers and supervisors may not be aware that discrimination is prohibited on these grounds and that they would have to deal with complaints on these grounds. If you are not familiar with the terms gender identity and gender expression, we will provide a link at the end of the presentation where you can get more information, or you can find the link in the resource list. Let us look at what you should do when you receive a complaint of harassment from one of your employees. Managers are responsible for taking appropriate actions promptly when they receive complaints of harassment. First and foremost, take the complaint seriously. Do not ignore the complaint. When a complaint is ignored, the behavior is condoned. I have sometimes heard managers telling the employee to wait a while and that the harassing behavior would stop. Harassment does not go away unless you intervene to stop the offensive behavior. Listen to the employee and find out the allegations of the complaint. Then advise the employee of any other steps that they would have to take under the policy, such as providing a written statement of the allegations of the complaint. Inform the alleged harasser of the allegations and find out what happened. Ensure the employee complaining of harassment and the alleged harasser are separated and not working together while you are handling the complaint. Find a resolution through mediation or investigation as outlined in your policy. Take the appropriate remedial action if there's found to be harassment, and maintain confidentiality of the details of the complaint to the extent possible. There may be staff or others that may need to know about the complaint in order to respond to it. For example, human resources or a staff assigned to deal with harassment complaints may need to know the names of the person making the complaint, the person against whom the complaint is made, and the allegations of the complaint. Also, if law enforcement authorities are involved, these names may have to be provided to them. Ensure that it is the impact of the harassment on the individual experiencing the harassment and not the intent that is important. For example, when I was a human rights officer investigating complaints that involved offensive jokes and other behaviors, the alleged harasser would sometimes say, "I just thought it was funny and did not mean to offend anyone." However, just because they did not mean to offend does not mean it is not offensive. to those listening to those jokes and those observing the behaviors. Use the reasonable person standard for determining harassment. That is, a reasonable person ought to have known that the behavior was unwelcome. As we saw earlier, the Alberta Human Rights Act prohibits retaliation. Ensure that no negative action is taken against the person complaining about the harassment, any witnesses, or anyone else that assists with the complaint. If you are uncertain about how to proceed, especially if you don't have a policy, call human resources people or your company's legal counsel and other resource people. You can also call the Alberta Human Rights Commission's confidential inquiry line to get information on responding to the complaint. The phone number will be provided later in the presentation. Employers can set a standard like the BAR standard for behavior in the workplace. The BAR standard stands for B, businesslike and professional. Be businesslike and professional in all dealings with co-workers or members of the public. A, acceptable in a work setting. Behave in a manner that is acceptable to everyone in the workplace. R, respectful. Be respectful of others and act accordingly. I'll now turn it over to Anne.
At this time, I will present an example of harassment in the workplace, and then we will take a few minutes to think about some questions. So here is the scenario. Wanda was hired as an office administrator. Men at the office frequently made sexual jokes and comments. She said she laughed at the jokes with the others and did not complain. Soon after she was hired, she began to receive emails with sexual jokes and offensive pictures. When nothing was done, and after it continued for about 2 months, she complained to the manager, who sent out an email to all employees asking them to stop any offensive behavior. The sexual jokes and comments stopped for a while before starting again. Wanda told the manager that he had not taken proper action to stop the harassment. He told her that he had tried, and they got into an argument. A week later, she received a letter informing her that she was being laid off due to cutbacks. This scenario provides an example of harassment. Take a minute to think about how this harassment could have been prevented. All right, so what should have been done to help prevent this incident? In this scenario, the manager should have provided a safe and healthy work environment for all employees. He should have ensured that a harassment prevention policy was in place and that all employees had a copy of it. He should have provided harassment prevention and respectful workplace training for all employees, and he should have role modeled the behavior that is expected of every employee. So what should the manager have done when Wanda first complained about the offensive jokes and comments? Take a moment or two to think about what steps should have been taken. Okay, let's see if you came up with similar answers. When Wanda first made the complaint, the manager should have taken Wanda's complaint seriously. He should have met with all employees and told them he would not tolerate any offensive behavior in the workplace, and he should have reminded them of the harassment prevention policy. The manager also should have followed the complaint procedures outlined in the policy to take action on the complaint when the offensive behavior continued. He could have called resource people, such as the human resource manager, the company's legal counsel, or the Alberta Human Rights Commission's confidential inquiry line if he was uncertain on how to proceed, and he should have ensured that no negative action was taken against Wanda. Now take a moment to think about what you would have done if a similar situation had occurred at your workplace. At what point would you have intervened to stop the offensive behavior? Okay, if you were the manager in this scenario, here are some suggested actions that you could have taken. You could have intervened right at the beginning, even before Wanda complained, if you heard the jokes and the comments directly. If you did not hear the jokes and comments, you still should have taken Wanda seriously and found out what happened. Since there were email messages, you could have looked at the messages, found out who sent the messages, and asked them to stop the behavior. And you could have informed them that the organization does not tolerate offensive behavior. You also could have taken the opportunity to remind all employees of the harassment prevention policy and provided training on preventing harassment and on how your organization's policy is to be implemented. These are some of the actions that, had you been the manager, you should have taken to respond to Wanda's complaint and prevented future complaints of harassment. So we've now come to the end of the formal presentation, and we are ready for your questions. So please be reminded that your questions will remain anonymous to other participants on the webinar and will remain confidential with us here at the Alberta Human Rights Commission. We are unable to answer questions related to specific human rights complaints. If you have questions about a specific situation, you can call our confidential inquiry line. Or if you want more information about our complaint resolution process, you can visit our website. We will provide the contact information for both of these resources later in the webinar. So at this time, please go ahead and type your questions related to understanding and preventing harassment in the workplace in the Q&A text box and click on Submit. If you've minimized your Q&A text box and you don't see it on your screen, click on the Q&A icon at the bottom of your screen. When submitting your questions in the Q&A text box, you will see two boxes. There's a smaller box at the bottom and a larger box at the top. Type your question into the smaller box at the bottom, and when you click Submit, you will see it pop up into the larger box above. So let's have a look at our first question. It is, if we are conducting an investigation following a complaint, what information should we or are we required to give to the complainant? Sheila?
The main things I suggest are, first and foremost, acknowledge the complaint. Inform them what you will do to respond to the complaint and how long it is going to take. When the investigation is completed, inform them of the result of the investigation, and if there's found to be harassment, advise them that you will be taking action to ensure that the harassment does not continue. Those are the things that I would suggest. Is there another question, Anne?
Yeah, related to that, once the investigation is complete and there is found to be harassment, are they required to discipline or terminate that employee?
Okay. If there's found to be harassment, the organization or the employer is required to take appropriate remedial action. I suggest basing it on each allegation and considering it seriously and cautiously. Take into consideration the seriousness and frequency of the harassing behavior. And I would also suggest that you consult with your human resources personnel and or legal counsel. When the investigation is being done, just ensure that the investigation was done in a fair and impartial manner. Any other question, Anne?
We have one here. You talked about this a little bit. It's asking if there's an allegation, is there a particular process involved with reference to the organization investigating this situation? And should this at any point involve external parties?
If there's an allegation and there is an investigation, some organizations use external investigators. Others choose, they have somebody trained, a trained investigator within the organization that they use. What was the first part of the question? Can you repeat that, Anne?
Yeah, I can. It asks, if there is an allegation, is there a particular process involved with reference to the organization investigating the situation?
Yes. The organization should put in a process as to how you would investigate the complaint, and that would include whether you would be hiring somebody from the outside to investigate or an internal person that is trained to do the investigation. Each organization is different, so I would suggest that the human resources personnel and managers decide on what the process is going to be. What you need to keep in mind is that you need to take action as soon as possible and not let it go on for a few months before action is taken.
Okay, thanks. That's really helpful. We have a couple of people asking a question related to the reasonable person test that you talked about earlier. Can you define what a reasonable person ought to have known? Can you define what that means for them?
A reasonable person refers to what is acceptable in the workplace. And is the behavior unwanted? We know some of the behaviors, offensive jokes, unwanted remarks, derogatory images that are not acceptable in the workplace. So the reasonable person is knowing what is acceptable in the workplace and basing it on your workplace and workplace culture.
Okay, thanks. The next question here, we have a question asking, is it correct that harassment is based on perception? I can give you a little more information about that. They're just saying, how can someone prove that they felt harassment just because the other person looked at them in a way that they perceived to be inappropriate?
And that comes back to the where we talk about harassment and we say it's one serious incident like sexual or physical assault and a series of incidents. If someone is looking at a co-worker in a certain way, and the first person finds that it is unacceptable behavior, then the employee should inform the co-worker that they don't accept that behavior or they don't welcome that behavior. And if it continues to happen, then they should let somebody in the organization, their manager or supervisor, know. So it is not just perception, it is the behaviors and the language, the comments that are made in the organization. And so for the employer, it is making sure that there is no unwanted behavior in the workplace, especially based on the grounds in the human rights legislation.
Okay,
anything
our
else?
Next question is going back to investigation. It's saying once an investigation is complete and there is found to be harassment, are they required to discipline or terminate that employee?
I thought I answered this question, but maybe I did not. If there's found to be harassment, then the employer is required to take remedial action, basing it on the allegation, considering how serious the allegation is, how frequently it's been happening, whether the individual was told not to behave or use certain language, unwanted language, and it continues. And then talking to human resources or legal counsel for more information.
Okay, does an employee have the right to refuse work that is assigned by a supervisor who is harassing him or her?
The employee is expected to continue to do the duties of their position. Any work assigned as part of their duties would have to be carried out. If the employee, as I'm thinking about it, if the employee is now being given other duties, for example, the supervisor is making this person run personal errands or other work that is not part of their duties, that's when I would question the work that the supervisor is giving. And then I suggest talking to your human resources people or to the manager involved.
Okay, the next question is about the reporting of an incident. The question asks, if an employee is unwilling to report an incident, What are ways of dealing with a harassment issue or a poisoned work environment indirectly, other than with trainings or reissuing the harassment prevention policy? Are there other things that they could do in that scenario?
Based on the kind of behavior that occurred, I would bring that to the attention of employees and reinforce that that is unacceptable behavior in the workplace. For example, if an employee is making unwanted, offensive jokes and is continuing to make those jokes, then I would use that as an example to stop the behavior. And then if the behavior continues, then you may want to take other more serious action.
Okay. Our next question says, are the consequences for sexual harassment different for a coworker than it is for a person in a position of authority?
The consequences are different. The employer, which includes the management team, is liable for sexual harassment. And human rights tribunals have frequently stated that employers should be held liable for harassment by management, including their supervisory personnel. I would like to emphasize that all harassment is serious in the workplace. However, managers and supervisors are seen as the role models for their employees. And when they are harassing their employees, it is taken much more seriously.
Okay.
Do you have another question?
Sheila. Yeah, there's a question here. You had talked a little bit about jokes in the presentation. Our next question is, are dumb blonde jokes considered to be harassment?
Dumb blonde jokes are derogatory and they demean women in general, and so they are not acceptable in the workplace. So dumb blonde jokes would be seen as sexual harassment if it's ongoing, if the individual is told to stop the behavior and it's ongoing. And it would be gender discrimination and so sexual harassment.
Okay, thanks for that, Sushila. You've talked a little bit about developing a policy on harassment throughout the presentation and within the questions that have been answered. So the next question is, how would I go about developing a policy on harassment?
Oh, that's a good question, Anne, because we do have something on it. You may want to listen to the webcast, Developing and Implementing a Harassment Prevention Policy, and it is available on the Commission's e-learning page on the website. A link is also provided in one of the slides in today's presentation.
Okay, thanks for that. I think we just have time for one final question here. The question is, can you tell us what the next webinar on harassment is all about?
That's another good question because we have a webinar coming in 2 weeks. And the topic of the webinar is going to be, I am being harassed or witnessing harassment. What can I do? It is about the actions that employees can take when they are being harassed or witnessing harassment in the workplace. That webinar is going to be held on April 27 at the same time from 1:30 to 2:30 p.m.
Okay, great. That was a great question that helps us promote our next webinar, so thank you for that. That's all the time that we have for questions and answers today, so thank you so much for submitting your questions. I hope that the answers provided were helpful for you as you deal with harassment in your workplaces. If we ran out of time before your question could be answered, you may email it to us at educationcommunityservices@gov.ab.ca. So we'd now like to provide some final information and resources to help you with preventing harassment in your workplace. Links to where you can find these resources will be provided at the end of the presentation, or you can find them in the resource list. The Alberta Human Rights Commission has a number of resources to assist you, including 2 information sheets related to harassment. They are entitled Harassment is a Form of Discrimination and Sexual Harassment. We also have 2 information sheets that provide additional information related to the areas and grounds that are protected under the Alberta Human Rights Act. They are Protected Areas and Grounds under the Alberta Human Rights Act and Areas and Grounds Protected, which is a quick reference sheet that outlines which grounds are protected in each area. Please note that the Commission has developed a Notice of Changes to Alberta's human rights legislation, which provides information about the two expressly prohibited grounds of discrimination, gender identity and gender expression. For more information about these protected grounds and to access this document, go to the Commission's website and search Notice of Changes. Another resource available to you is a video scenario on sexual harassment that you can access on our YouTube channel called Indira's Story, which portrays Indira's experiences with sexual harassment at her workplace. You can find it and other video scenarios in the e-learning section of our website or by going directly to our YouTube channel. We also have a webcast that provides an overview of Alberta's human rights legislation, the Alberta Human Rights Act. The purpose of the Alberta Human Rights Act is to ensure that all Albertans are offered an equal opportunity to earn a living, find a place to live, and obtain services customarily available to the public without discrimination. The webcast is entitled Alberta Human Rights Act Overview and can be found on the e-learning page of our website or by going directly to our YouTube channel. Finally, if you have a specific situation or want to learn more about making a human rights complaint, you can call the Commission's confidential inquiry line to speak to a human rights officer. The information is listed here, or you can visit the Contact Us page on our website. For more information or to access our resources, please visit our website at albertahumanrights.ab.ca. Access our e-learning resources by clicking on the e-learning link in the Quick Links bar. To get copies of the information sheets noted or any other information sheets or information bulletins, click on Information Sheets under the Quick Links bar. To view the videos on our YouTube channel, go to youtube.com/Alberta Human Rights or search Alberta Human Rights Commission in the search bar. And you can also link to our YouTube channel from the e-learning page on our website. As mentioned, you can contact us by email at educationcommunityservices@gov.ab.ca.